This is a California legislative explainer on how a bill becomes law in the state. Now, for those not fully acquainted with the California legislative process, new laws, which we call statutes, are enacted by the legislature through bills and signed by the governor to become statutes. The legislature can also amend or repeal existing statutes, also with accompanying gubernatorial action. Pursuant to Article 4, Section 8, the legislature may make no law except by statute and enact no statute except by bill. Hence, the first thing is that statutes need bills. So whether a statute is adding, amending, or repealing, that process must be done by a bill that is passed by the legislature, both houses, the Senate and the Assembly, and signed by the governor, or the governor can allow a bill to become law without his or her signature. According to the legislature, the process of government by which bills are considered and laws enacted is commonly referred to as the legislative process. So, in looking at the legislative process, a bill must be approved by both houses of the California legislature and then sent to the governor for final action. It is a bicameral body, so the legislature is composed of two houses, the 80-member assembly and the 40-member Senate. The legislature, similar to the Congress, meets in 2-year sessions. A bill is approved generally by at least one policy committee, sometimes two, and often a fiscal committee in about 75% of all bills. And this has to occur in both houses. So once adopted by both houses, the bill is sent to the governor, who may sign it or veto it. This process can take a number of months, sometimes even the entire 2-year legislative session, and in some instances, even longer. Bill ideas and drafting legislation. Policy committees, again, used to consider the policy impacts of proposed legislation, and the fiscal committees, which are used to consider the fiscal impacts of proposed legislation, hear and consider and ultimately vote on legislation after gathering input from interested parties. These bills come from ideas that are put forth by constituents, interest groups, staff, legislators themselves. Once a legislator decides to author a bill, he or she seeks to have the Office of Legislative Counsel draft the bill for introduction. For a bill to be introduced or even amended in the California legislature, it must be in Leg Counsel form, which is short for Legislative Counsel. Bill introductions and referral. Thereafter, the legislator introduces his or her bill in the Assembly, if an Assembly member, of course, or in the Senate as a senator, of course. The bill is then assigned a bill number and read publicly for the first of 3 times. Again, this is the first of 3 required readings pursuant to the Constitution. Thereafter, the respective Rules Committee of the Senate or the Assembly assigns the bill to one or more standing committees for hearing. The proper committee referral is based upon a number of subjects, including the subject matter of the bill and the jurisdiction of the committee, and where similar bills have been sent in prior years. Thereafter, the first hearing in a policy committee is held. So once the Rules Committee has assigned the introduced bill to a policy committee, the bill is heard by that assigned policy committee and perhaps an additional policy committee or onto the fiscal committee if there are potential local or state fiscal implications of the measure. At this committee hearing, the author presents his or her bill, and the proponents and the opponents are permitted to speak briefly at the hearing in support and opposition. Thereafter, a vote is taken, and the motions are either to pass it or to pass it with amendments. The third option is to defeat the bill, to vote it down. The fourth potential option is to withdraw the bill or perhaps hear it at a later date or during an interim recess. Thereafter, again, roughly 3 out of every 4 bills go on to the fiscal committee. So the vast majority of bills are referred to at least one policy and fiscal committee. Once the committees consider the measure, then the bill goes on to the floor of the Assembly or Senate, and once passed in the House of Origin, must complete the same process in the other house or the second house. Throughout this process, there are several opportunities prior to and during these committee hearings for interested persons to express their views on the pending legislation. Making your voice heard. The committee staff prepare an analysis of the bill and its potential impact on existing law. It's also important at this time to express your view on legislation, and that should be done prior to the committee hearing so that your views can be considered before legislators vote on the bill. They do want to hear from constituents and interest groups regarding pending legislation that they have to vote on. So as bills make their way through the legislative process, they may be amended either substantively or technically, and please keep that in mind prior to submitting your comments. Tracking legislative activity. Interested parties can track legislation through the process and determine whether amendments are favorable or unfavorable and whether or not somebody's position on the measure will change. These amendments ultimately need to be agreed on by the House of Origin, a concurrence vote, and before it reaches the governor's desk. So what is concurrence? The same process occurs in the second house or the other house. Policy committee, fiscal committee, floor debate, and vote. Now, if there were any amendments made in that second house or the other house, then the bill must return to its house of origin for a final vote on whether the house of origin accepts or rejects the other house's amendments. If they're rejected, then a two-house conference committee is convened to potentially resolve those differences. On the other hand, if those amendments are accepted, that is, they are concurred in, then the measure goes on to the governor's desk. And the last step of the process is gubernatorial action. The governor generally has 12 days upon which to act on measures. Between 200 and 300 bills each year are subject to that period. Due to the large volume of bills that are sent to the governor's desk at the end of session, they have roughly 30 days in which to be evaluated and acted upon. And these can be 700 to 800 to more than 1,000 bills during that final signing period when the governor has roughly 30 days to act on those measures. The governor does have the option to allow a bill to become law without the governor's signature.